What do you do when a president disregards the oath of office? How do you stop a president? That's the last third of the book that I'm focused on. Washington, notice, in calling for constitutional punishment for himself, is recognizing that the office is different than the person. The office, in an important way, is above the person, distinct from the person who occupies it, and the person can disgrace the office such as to require constitutional punishment. I don't think he thought he was going to be subject to it, but he was sending a message to future presidents, thus the subtitle of the book, that they might be deserving and subject to constitutional punishment. So how do you do it? Let me say something first about the ongoing question, very live, used to be a hypothetical, now very live question, of whether or not you can indict a sitting president. The framers just disagreed about this. Alexander Hamilton seemed to think impeachment came first, and after removal, when the former president was a private citizen, then a criminal indictment could be possible. James Wilson in the ratifying convention in Pennsylvania said the opposite. A president basically can be subject to indictment. They don't help us much. But what does help us is case law. U.S. v. Nixon, 8-0, making it very clear that one principle that my 11-year-old, to whom the book is dedicated, can understand: a president is not above the law. A president who breaks the law can be subject to a criminal subpoena for information, but more than that, not just during a criminal trial, as was the case there, and you heard Judge Kavanaugh try to limit the idea to a criminal trial, but more generally in a grand jury. And more than that, I believe, the principle stands for the idea that a sitting president, distinct from concerns about impeachment, can be subject to criminal indictment. Now, there's a memo that says otherwise. There are actually two, one written during the Nixon administration and one written later during the Clinton administration. This is a bipartisan problem, this idea of making immune a sitting president. And they rest on two ideas. One is the notion that the president is special in that he or she is the head of the executive branch, and the whole branch will be imperiled if there's an indictment. Basically, the idea that the president is too busy running the country or the executive branch in order to be subject to indictment. That was answered in the Paula Jones case, Clinton v. Jones, with a very simple point. The courts can work with the president. The president has a scheduler. The nuclear suitcase can be moved around the earth at a moment's notice. They can figure out how to make time for legal proceedings if a president is criminal. The more important argument and mistaken argument, I think, is about the dignity of the office. That the dignity of the office somehow immunizes a president from indictment. And I think that's answered by Washington. The person who occupies the office is distinct from the office. The office is in many ways above that person, such that if that person disgraces the office, they should be subject to, as Washington said, constitutional punishment. I don't know that he was referring to indictment, but the point that he was making certainly applies there. Let me say something about our friends James Madison and Thomas Jefferson, who I mentioned early on. I said that their party was basically shut down by Adams. There was a time in which it was illegal to criticize the president, even if you were the vice president. Now, what did they do? They left Philadelphia, the capital, the sitting vice president, and the main drafter of the Constitution, who wrote the main notes that we have about it. They went back to their home state of Virginia, and they got their legislatures in Virginia and Kentucky to pass a resolution saying, not that the law was nullified, Jefferson toyed with that in a draft, but that they wouldn't enforce it. They weren't going to cooperate with the federal government. Now, that's a sort of less obvious strategy about resisting a president. But when you look to California, I have a former Brown student who introduced me to his uncle, Miguel Marquez, who I talk about in the book, who's leading the charge against the attempt to require localities to cooperate with ICE and hold for 48 hours people who are suspected of being undocumented just because they've been stopped for a traffic violation. That's the tradition here of Jefferson and Madison refusing to cooperate legally with federal agencies in matters especially that are unconstitutional. That court case is going through the courts now, and Marquez and his team have won some very important early victories, a less obvious way of resisting. The final way, I'm not going to say that much about because I think you all have opinions about it, but the idea of impeachment, I think has to be kept very distinct from the criminal question of indictment. There is no category of high crime in the criminal law. If you take 1L criminal law, you're not going to learn about a unit called high crimes. It's a political category. And to me, what it's about is the idea of misdemeaning, lowering oneself when it comes to the office. A political criteria for thinking about whether or not there is a president that has so disgraced the office and so disregarded the oath that he or she might be subject by the Congress to a political form of constitutional punishment. Now, I'll just sum up by saying this is a very different idea of the presidency than Wilson had, certainly, than many scholars have. Many people have called for expanded power of a president. I saw in a bookstore today a pre-Trump book about the need for a tougher presidency, a more powerful one. And I'm trying to make the case for Washington's vision of an Article II bound limited presidency. That means respect, not just not violating the Constitution when it comes to free speech or the Eighth Amendment ban on cruel and unusual punishment. It means going beyond that and doing, even when the courts don't require you as a future president to respect the Constitution, going out of your way to do so. So yes, there is no jurisprudence saying the Eighth Amendment bans torture for the extraction of information by the executive branch. But a president that we elect has to respect that rule. A president also, in his or her own speech, has to use that speech to defend the Constitution, not to, as Wilson did, disregard or disgrace it. And then I ended, after talking about these provisions, with the idea of indictment. Yes, there is disagreement. I don't want to doubt it. This is something that courts will have to decide. A future Supreme Court might well decide that question, including perhaps a Judge Kavanaugh, depending on what happens. But in my view, the right answer is yes, a president is not above the law. That idea in U.S. v. Nixon and in Clinton v. Jones. Supreme Court cases rather than memos written by mid-level Justice Department officials.